Hello and welcome to Undisciplined, the podcast about philosophy, politics, legal theory, geography. Today I have an amazing guest. We've been really blessed with great guests lately. Today I'm speaking to Professor Samuel Moyn, who is a professor of jurisprudence and a professor of history at Yale University. Sam has written too many books to mention, but today we will be talking about law and political economy as well as critical theory. Sam is also a host of Digging a Hole podcast about legal theory. Link to that in the description. If you like the podcast, remember to subscribe, remember to like, and don't forget to check out my book on international law, legal theory, and politics. All of this is in the description below. Anyway, here's my conversation with Sam. Thank you so much, Professor Moyn, for coming on my podcast. I really appreciate it, and it's an honor to have someone of your caliber and pedigree on my podcast. Firstly, I don't think it's very necessary, but for formality's sake, do you mind giving a brief introduction of your background academically, and especially because I think you have a very interesting position for me in the sense that you're dealing with law in this kind of triangle between law and history and legal theory or legal philosophy. And this is also a kind of a triangle that I work in myself. So if you could maybe give a bit of your background and why you find yourself within this triangle. What led you to that?
Well, thanks for having me, first of all, and please call me Sam. I think I come by those interests just, biographically. I went to university in the Middle West of the United States where I was born, and I was introduced to European intellectual history, including some aspects of critical theory. And then I pursued those interests by starting a doctorate in European history. And my doctoral mentor was Martin Jay at the University of California, Berkeley, who really wrote one of the first leading histories of the Frankfurt School, but also was especially interested in traditions of critical theory in kind of the broadest sense. But I also went to law school, and I encountered eventually, not right at the start, some of the figures at Harvard Law School who had founded the critical legal studies movement. And really from that beginning point, I've been trying to understand what it would mean to have a critical theory of law, because the first group of influences I met, at that time were not terribly interested in law. I mean, it's true that in the 90s when I trained, there was Jürgen Habermas kind of taking on legal theory, and a lot of us were extremely interested also in the implications of deconstruction for legal theory, because Jacques Derrida it took the topic up, notably in a long essay, Force of Law. But I'd say when I got to Harvard Law School, where I did my law degree, there was not much discussion of any of that. Instead, there was this thing called critical legal studies, which no one in Berkeley had ever mentioned. So I was, in a sense, trying to understand how to connect these two pieces of early exposure to ideas I had, and I probably am still struggling.
Yeah, perfect. So I think that brings us very much to your recent work that I would really like to talk about today, also for very personal, personal academic or intellectual reasons, because I feel something kindred in what you're writing in my own thinking. Mm-hmm. And I'm specifically speaking about an article that you recently wrote, Reconstructing Critical Legal Studies, where you are fairly critical of CLS. And I think the first claim that I take from that contribution of yours and where I feel an affinity to is you start from the premise that we need a new critical theory of law. And the implication of that is that CLS is over and it achieved some things, but it was also limited in other ways. My question is, why do we need a new theory of law in 2024? And why can we not continue with CLS anymore? What was wrong or not useful in CLS anymore? And which parts of it are worth saving for this new theory that you're hoping for?
Oh, it's a really important, excellent question. I mean, maybe I should begin indirectly by returning to, my own path, because I left off with my student days. And I had a circuitous journey thereafter, but I've ended up teaching, among other classes here at Yale Law School, a class called Foundations of American Legal Thought. And that's a canon class understood as reviewing the history of American legal academia, what were its major tendencies. And it's in that context that I first began to return to some thinking I did in my student days about where radical legal traditions fit in legal academia, if at all. And it was after I taught the class that I wrote this essay. So I wrote it because I was reflecting on this kind of novelty in the context of American argument. We could get into how broadly applicable it is, but just in a few years, the consequences of the 2008 financial crisis finally led to a rekindling of a desire for a kind of left radical legal theory, after a period in which CLS, sort of the main such theory, had been seen as dead, superannuated, whatever. And so the question was, what would this theory look like? And before I tried to intervene in this way with this paper, which is finally coming out in a month or two, it impressed everyone, I think, and rightly so, that there was an attempt to found a movement called Law and Political Economy. And that I found it interesting that many of those radicals I talked to, especially from teaching outside the United States, were very hostile towards critical legal studies. And the same was true belatedly of the law and political economy movement. I was on, many Zooms in a lot of kind of meetings in which the basic principles of any of this new theory were mooted. And you could tell that the leaders and many of those kind of early adopters of the law and political economy perspective were skeptical of critical legal studies. So I then I don't have a large stake in what a new theory is called. I kind of assume that, whatever we call our theories, they will owe things to the past regardless. And the main question is always, what should we take from the past and what should we add to it now? What I wanted to do in this paper is to say that there were important, let's call them breakthroughs, that the critical legal studies, if it were fairly reconstructed at least, could add to our search today for a persuasive approach. And so that's the attitude of the paper. It's critical of CLS, but compared to many who just scapegoat CLS, more or less ignorant of it, it's also in a sense, protective and rehabilitative in relation to CLS, at least some elements of it which deserve that treatment.
I see. That's interesting because I read the article as a repudiation of CLS, and without the context that you gave now, and now that I have that, I understand that it's not I wouldn't say a defense of CLS, but trying to find some of its redeeming qualities.
So there's a strategic reason, in for the framing of the paper, which then I totally understand your reaction to it, which, we say, if you can't beat them, join them. And what I wanted to do, in part because I think it's convincing to do so, is concede a lot of the criticisms and skepticism of CLS that are in the air because they're well-founded. But what I wanted to show as well is that those criticisms really hit the target not of CLS, but really of one branch of it. And even that branch, I think, has an undeserved reputation for the main stance which is being rejected, which is the alleged commitment to the indeterminacy of law. And so it's true. I want to concede a lot to the criticisms, but also say that there are at least significant elements of CLS that aren't subject to those criticisms, and indeed made some contributions that need to be reclaimed, no matter what we call the movement doing the reclaiming.
I would love to come back to the things that need to be reclaimed or kept. But before I do that, I want to ask a little bit more about, you said you experienced this kind of rejection of CLS in with other people that you spoke to. And then in another of your papers that came out recently that I'm also very interested in is titled Critical Theory's Generational Predicament, where you very shortly argue that basically critical theory and the Frankfurt School style critical theory has failed to pass itself on to newer generations for various reasons. And for me, critical theory and CLS, at least in my mind, has always gone together a little bit, at least in the context that I learned both of them. So what do you think, before we get to what can be kept from CLS, in CLS and critical theory, why do you think there's been this gap in transmitting it to the next generation? Why is there this hostility to CLS that you saw, and why is there this disinterestedness in critical theory?
So that other paper, which has been published, is due to my membership on the editorial council, I think it's called, of the, let's call it, Frankfurt School journal in the United States called Constellations. And they asked everyone on that council to write something about the state of critical theory for the 100th anniversary of the origins of the so-called Institute for Social Research, aka the Frankfurt School. And it's really in that context that I wrote up my thoughts. And there is a connection. I think there are several connections between the two papers, because one aspect of what CLS stands for, I think, is what we could call, in a broad sense, a kind of Western Marxist impulse to save critical theory from vulgar forms of reduction. There's a very good paper by a colleague at Princeton University named Edward Bering, who goes back to the very beginning of Western Marxism, which antedates the Frankfurt School. It's usually said to have been founded by the Hungarian theorist György Lukács. And Bering shows that really kind of there's this founding gesture in Western Marxism, which is the rejection of so-called vulgar Marxism. And I continue to think that's an indispensable move, and it then affects what kind of critical legal theory we should want today. And I think just to anticipate our later conversation, what CLS was doing, among other things, was protesting against vulgar forms, especially of class-based reductionist legal analysis. Now, the paper that you asked about, which is the generational predicament one, is also connected to the Reconstructing Critical Legal Studies paper, because I think that both bodies of thought are in the position they are because of generational effects. And roughly, I would put it like this: young people have an attraction, let's not say in an inflammatory way, to vulgar Marxism, but to, let's say, more vulgar forms of Marxism than their elders. And again, I try to concede a lot to that impulse, because it's just true that critical theory lost touch with the economy. And the whole ascendancy of Western Marxism in academic discourse really was in a kind of culturalist vein that left the standard bearers of critical theory in the kind of like older generation today really not prepared for the crisis of capitalism, or whatever you want to call it, that is central to how young people after 2008 understand our times. And so I think what I would say is that critical theory in general was out of position. And that doesn't mean it is rightly rejected or scapegoated, but it set itself up for that fate. And so what I ask of those of my colleagues and friends who really do think of themselves as part of the legacy of critical theory in a broader, narrow sense, is that they, hold up a mirror to themselves and ask how they lost their way in the face of neoliberalism, and reformulate their positions so that they can continue to make the argument for a more sophisticated Marxism against a vulgar one that really founded their whole intellectual school of thought.
We see that there's this difficulty in transmitting these ideas to a next generation. But as we said earlier, you also feel that, we shouldn't throw the baby out with the bathwater, and focusing maybe a bit more on CLS again rather than critical theory. I want to talk about what is to be kept or saved in CLS. And in doing that, you make this distinction. You talk about underdeterminacy, and you distinguish it between its functional side and its interpretive side. Do you quickly mind explaining the difference between these two forms of underdeterminacy that CLS identified, and what is important in that for us going forward?
Absolutely. I mean, that is really the core of the exercise. So it's useful to just summarize some of the claims of the article. So I'll start by saying, for those, in the law and political economy movement and elsewhere, in the burgeoning crew of Marxist legal theorists, CLS, when it is scapegoated, it's because of its alleged commitment to something called indeterminacy. And when I look back, I find that this is at best a half-truth, maybe not even half, because there were a lot of people in critical legal studies. The most famous, I think, kind of the one taken to epitomize critical legal studies, or the iconic one, Duncan Kennedy, a Harvard law professor for many decades, in a sense, achieved a lot of success in kind of defining what the central ideas of CLS were. But from the beginning, there were other people. And I mentioned two just because they were his colleagues at Harvard, in fact, in a certain way, senior colleagues. One was Morton Horwitz, who was not a Marxist. I would say his thought had features of vulgar Marxism. His early thought in an epic-making book he wrote called The Transformation of American Law. And then there was a teacher of mine, Roberto Unger. And basically what I want to say is that when we look at their thought, all three of them, as founders, it becomes very difficult to assign a commitment to something called legal indeterminacy to CLS, and therefore easier to reclaim a more sophisticated understanding of what's at stake. So you're absolutely right that I distinguish two forms of commitment to determinacy in law and something that is an alternative to it, which you rightly, referred to as underdeterminacy. And those two ways are functional and interpretive. They may be related, but I'll just keep them separate. So the basic idea of functional determinacy is that the law serves the purposes it is devised and deployed to serve. And a classical example of this would be a Marxist functionalist account of law, like in Jerry Cohen's, also very well-known book, Karl Marx's Theory of History. There's a motor of history, and law is part of the superstructure. And law then is there to assist instrumentally in the achievement of the purposes of capitalism, however defined. And I try to show that Horwitz adopts a view like this. So if he's committed to a view about this, it's a view about the determinacy of law functionally. Then I look at not so much Kennedy, but his disciple, Robert Gordon. And what I try to show is that whatever Kennedy's views were, Gordon, who was a Yale law professor, wrote a well-known essay called Critical Legal Histories, went very far to try to show that law is so functionally underdeterminate that we can't establish any causal relation between, broad social purposes like, the ruling class's interests on the one hand and legal outcomes on the other. And he basically pursues that argument by saying, well, there are many different legal arrangements that would serve the same end as one another. And therefore, when we're trying to explain one arrangement as opposed to others, we can't rely on the function that the law is serving. There are the function underdetermines the legal outcome. And what this does is, in a sense, put pressure, explanatory pressure on a kind of, especially a vulgar Marxist framework, which, Gordon openly rejects. It goes so far, as I try to show in the paper, that it's almost like a rejection of explanation. And so what I want to say is that those who are uneasy about CLS because it made the kinds of criticisms of capitalist law impossible are on firm ground. But not with respect to CLS, but with respect to Kennedy's legacy in Gordon's essay. And then I try to show that this third character, Roberto Unger, tried to kind of get a balance right. And arguably, that's what we should do. We should want to understand how law serves purposes, but also understand how there's some underdeterminacy in the system. And then broadly, when I switch to interpretive underdeterminacy, I follow the same agenda, which is to say, when we look at how CLS thought about the instability of legal meaning as interpreted, especially by judges in cases who actually have a lot of legerdemain in resolving cases one way or another based on interpretive protocols. Well, some people in CLS, notably Horwitz, seem to have implied that this wasn't an important feature of law because judges serve the ruling class. Then there were some who assigned them extraordinary agency to be free agents using their interpretive power to achieve whatever ends. And similarly, I basically try to argue that we should never be so vulgar as to reject the interpretive lability of law. I mean, anyone, the first year in law school, you understand very quickly that law is made to be interpreted, and it's not straightforward. And so rejecting that would be like self-inflicted blindness. But at the same time, we do have to understand what people in CLS called the law's tilt. It is the case that whatever the interpretive underdeterminacy of law, it serves the powerful most of the time. And that's what has to be theorized.
You said you don't have a stake in what it's called, but let's, for the sake of our conversation, call it law and political economy. So the movement, law and political economy, which might be the next great, let's say, label or generation of radical legal theory. Maybe for people who are not familiar with it, how does law and political economy frame its problems and frames itself, and how does that contrast from the previous generation of CLS?
Law and political economy it is like CLS. It's not an it, it's a they. There's a host of different projects. I privilege the kind of first emergent one, when there were manifestos being written. But of course, when one looks at the rank and file of those who affiliate with law and political economy, which includes me, you find lots of different views. And its blog is just terrific, because you've just find a kind of raucous exchange, and it's just hard to say exactly what it does stand for as a result. However, when you look at some of those early founding documents, I would say that the movement comes off as being like a New Deal restoration project, or a progressive movement restoration progress updated for our current sensitivity to disempowerment because of gender, race, indigeneity, disability, and so forth. So it's about class plus and class unfairness. And I think, though it's not Marxist in any of those early documents, I mean, it seems like it has a vulgar tendency. All I mean by that is that it seems like for the law and political economy, there's not a lot of mystery. Law serves the dominant. And that's what legal theory is about unveiling. And then it should be kind of reclaimed for the rest or the weak. I will say, they're outside the United States. There are a lot of Marxist. Some of them kind of have become part of the law and political economy movement. And I'd say they are very interested in restoring a relatively vulgar Marxism in many cases. And an example of that would be the excellent article written against mine by a Columbia law professor named Jeremy Kessler, which is entitled Law and Historical Materialism. And it basically takes Gerald Cohen's perspective on the law, and it's almost, proudly vulgar in its Marxism. And so I guess the reason I wrote my piece is my sense that a lot's going to be at stake in whether, we just respond to what's going on today by saying, no, we need a very simple theory of law that says it serves domination in a simple way, or whether we need, something like Western Marxism or like CLS, the important elements of which we're attempting to, complexify, not reject. The kind of righteous denunciation of injustice, and so that's what I wanted to kind of add with several others to the ongoing debate about law and political economy.
Maybe picking up on this distinction of vulgar Marxism or not, and I want to play devil's advocate a little bit,
please.
And of course, I don't take you as the figurehead of law and political economy, so I'm not expecting you to answer for for it. But just as a kind of an intellectual exercise, you claim first in your paper that we need a new radical legal theory, and then also just in the name, and you said you're not committed to the name, but in the name, law and political economy. My question being, does a legal theory, firstly, does it have to be a radical one that argues for change? Does it have to do that? Do we have to have a legal theory that refers to the externality of law, as in politics, economics? What I'm thinking of here, of course, in contrast is, typical old school positivism in the sense of like Kelsen. To summarize my question, do we need something pure, a pure theory, or is it important that we have a radical theory, and do we win or lose by having a legal theory that is not pure but refers to the externality of law?
It's a wonderful question. In this class that I mentioned, it's called Foundations of American Legal Theory. But the year I wrote this paper, I was the only teacher, and normally a kind of team taught class. So I did what I wanted, and I assigned a lot of Hans Kelsen. But so first, I believe in an ecumenical intellectual life, radicals, reactionaries, impure theorists, pure theorists, and whatever people think is worth pursuing intellectually deserves our attention and engagement. My own view about the pure theory of law is that it's politics by other means. And I think the most brilliant statement of that is in Judith Shklar's book from the 1960s called Legalism, in which she argues that the motivation for purifying law turns out for Kelsen and possibly his followers to have been a political one. And so there's a performative contradiction, if you like. And then if that's true, then it might counsel, just a more explicitly political stakes for legal theory rather than pretending that they could be purged. But I don't at all think, it's obviously not the case that radical legal theory is the only kind, because actually there has been precious little radical legal theory, especially in my country, in law schools, but even generally. And so anyone interested in legal theory has to contend with the dominant and mainstream forms of the practice. And therefore, I think, a positivism in our language, HLA Hart's version of it, is indispensable. Is it something we should want to pursue ourselves? That's what's in question, as far as I can see. And I guess I would argue that maybe if it turns out that, let's say, positivism is liberalism that dare not speak its name, well, it might turn out that the theory is politically sterile, like it adds nothing to the liberal cause. And if that were true, then there would be no reason to pursue it any longer.
Yeah, I think that's a good point. However, do you also, I wondered to what extent I believe that any legal theory that gains any kind of traction will speak to the environment and the times in which it arises and what it reacts to.
For sure.
I think I'm not being controversial saying law and political economy is reacting to a certain phase of neoliberalism that we're inside.
Absolutely.
Do you think that this context is universal enough, or you mentioned you're getting a kind of a different flavor of it from outside the US?
Yes.
Yeah. Do you think it's something that's going to be American, or does it have international, global potential?
Yes. Well, it surely does, insofar as, I've been surprised by how, mobile it's been. It's worth saying that of the founding, figures, most of them didn't work on U.S. law. They worked on international law or global law, like David Graywall or Amy Kapczynski at that time. It's true it was founded by Americans, but I've had the experience of going to certainly the United Kingdom and being waylaid by students in law faculties interested in propagating it, and then continental Europe. I think there's a similar phenomenon, but I guess I would put it in the following way. Of course, its concerns are narrow to an extent. It at least vulgar Marxism was not narrow, because it ultimately had the aspiration to explain everything about our society and culture. And there was a Marxist literary criticism. There was a Marxist history of philosophy, et cetera, et cetera. Law and political economy is a fledgling entity. Maybe it's part of a broader, Renaissance and historical materialism, Marxist or not, that will take on the ambition of older forms of Marxist inquiry. But if that's true, it's early days. However, I would say that if, as I argue in the piece, we should want law to be much more connected to what I call social theory than it has been lately, well, then any theory of society, especially modern society, is going to place political economy pretty central. By that, I just mean that central to our social life is, production, distribution, exchange, consumption, and the legal regimes that make those possible and are inflected by them, and so forth. So I think that law and political economy, if you want, is narrow, but it's not narrow in the sense that its problems are narrow. And more than that, I would say that if it's directly a response to neoliberalism, Americans were some of the last people to talk about neoliberalism, which is a global phenomenon, and it's inspired debate about what it is and how to counteract it across the globe. So to that extent too, it's anything but parochial. But I think it's certainly a fashion, and like all academic fashions, in 20 years people will sit around wondering what that was about. But that's why, as an intellectual historian, I want to say, if we learn more about the history of the practice in which we're engaged, in this case legal theory, we can maybe have a more continuous sense of what people have thought, and how we can build on insights that others have had and not reinvent the wheel every time there's a commercial crisis.
This brings me something similar, but different. And I hope this is not too broad of a question, compared to my other very broad questions. But do you think that it's in legal theory and theorizing about the law, is there a place for international law in legal theory today or not? I mean, like classic public international law. Is this, you've said before that, you know, since the 90s or so, public international law is overestimated, or was overestimated compared to what you think today. But do you think international law still has an important spot in legal theory today?
I mean, I would have said it's never been more central to legal theory. I mean, It's true that someone like Kelsen becomes an international legal theorist, and Hart has a chapter on the topic in his book. But I would say some of the leaders in general legal theory lately have come out of international law. And I'd point to the section of my paper that we've been discussing about another branch of Marxists who I argue have accepted some of the insights of critical legal studies, in a sense blurring the distinction between these two approaches. And those people I mentioned, like Dina Tsuvala and Umut Ozu, are international lawyers. But I guess if you're asking, does international law as a body of law have a special place? Well, I think it depends on like what we're trying to do theoretically. I think on problem areas like, you know, capitalism or whatever you want to call it, which is inherently international and global, I don't see how you could take it up as a topic without taking up international law in the process. And I've written on the political economy of human rights law, and so have a lot of other people. So I assume it will be significant. I don't think it has a privileged place theoretically, but I don't know that anyone has ever thought it does. I mean, but I could be wrong about that.
Yeah, no, my question definitely comes from a space of my personal
yes
educational background and where I'm writing and so on. I wonder, we're talking about, you mentioned some of the excellent international law scholars that we have today, which just off the top of my head reminds me one of the more recent episodes I had was an interview with a double feature with David Kennedy and Marty Koskaniemi, and also speaking a lot about CLS, and they were saying how when they were young, being a critical international law scholar was, you were kind of on the edges, you know. It was, they don't use these words, but it was kind of like the punk scene of international law. But today, I don't know, 40 years later or whatever, saying that, you know, kind of that cliche of we're all legal realists now, we're all crits now.
Yes.
I'm wondering, and this is more a general question, not specifically related to what you wrote, but perhaps in a way, because you call for a radical theory, but to what extent, or what do we do when everyone in legal theory or legal philosophy, everyone is a crit? Like, no one is conservative anymore. We're all agreeing. We're arguing about the different flavors of critique. Yet somehow, you know, the machine keeps rolling on.
Yeah.
despite no one liking it?
Yeah, I think that's a great question. I think it's I think that's, I think it's hard to know because it's, I think this goes back to a period when the academy was much more reflective of the political cleavages of society, and a certain generation resolved to, having lost in politics, to win in intellectual life. And that went very far. I mean, one other thing that unites the two pieces you asked to talk about is that they're both about the dynamics of, let's call them the boomers in critical theory, who are precisely those who lived through what an author, Peter Starr, called the logics of a failed revolt in the 1960s. And their response was hibernation in the academy. And the trouble is that, in a sense, they produced a lot of people who can succeed them in their role in the academy, but they lost touch with the larger, politics of their moment. And so this is a huge dilemma, and I think it means that it's probably right that we need to diversify the academy so that we actually have enemies again, but also to find ways of, connecting with progressive social movements. And there, I think Law and Political Economy has been very insistent that it reject the critical legal studies paradigm, which was kind of the stance of the oppositional intellectual. And there's even a kind of new subservience in current critical theory towards movements outside the academy. Now, that doesn't mean that it's very powerful alliance politics yet, but I think everyone's grappling with the question you ask with no good answers yet.
And do you think that there's a way to? I'm not sure if it existed before, but do you think that there's a way to rebuild that bridge or build it anew? That bridge between legal science, legal academy, and legal practice.
Well, okay, so I think that would be very difficult because I have the sense that most crits of whatever, in whatever way you want to define that term, are not placing their hopes on the legal profession. They're skeptical of the legal profession. So if there's a kind of like agent out there to transform things, it's a popular agent, not an elite professional agent. And so this makes it very hard for those of us who spend our lives training professional lawyers to figure out like what we're doing there. But I don't know of many people who like believe or hope that law firms are going to be where the revolution begins.
Yeah. No, that seems that's not something I would place a bet on.
No.
Well, Sam, thank you very much. I don't know, I could talk to you much longer, but I thank you very much. Is there something I missed, or
No, it's been a very rich and substantive conversation. So I'm very grateful for your time.
No, thank you very much. And I hope you come on again in the future.
Sure.
Yeah. Thank you.